The Courts of First Instance allows us to bring a matter before the High Court concerning any criminal act committed against us by a state employee or their corporate body employer. I have identified potential violations of the Data Protection Act 2018 and the Criminal Justice Theft and Fraud Offences Act 2001. When I filed plenary summonses into the High Court a few weeks ago, I was denied access to justice based on the information which was within the plenary summonses. I got an affidavit back from Naomi Tamblin, who is a principal registrar, and she's a practicing solicitor within the High Court. In her affidavit, she disclosed that they made decisions based on the information which was in the plenary summonses, which at that stage were not issued, and they were private information. So whether it's plenary summonses or whether it's affidavits you file into the central office, that's your personal data. And under Section 36 of the Data Act 2018, permission has to be got off you to disclose that information to other people. Otherwise, it's an indictable offence under 144 and 145 of the Data Act, and the corporate body can be prosecuted under 146. So I'm using this principal registrar's actual affidavit to initiate a criminal trial in the High Court, and I have the authority to do it under the Criminal Justice Theft and Fraud Offences Act 2001, the Data Protection Act 2018, and the Court Services Act 1998, which shows that this corporate body and individuals working within it acted outside their statutory functions. Now, the fee regime that's there in the central office at the minute does not extend to criminal matters or constitutional matters, because the legislation underpinning the statutory instrument attracting fees only pertains to civil matters. And so that means you can begin your criminal trial without any fee payments on it. Now, the affidavit that I'll be filing in today will generate a record number. From that record number, I'm going to bring an application before the court for an order. So we draft our own orders as well too. And in the order, I'll be asking the High Court judge to issue a notice on the defendants to come into the court to hear my complaint and to respond. So that begins the process, and that's due process under Article 38 of the Constitution of Ireland. And obviously, all the defendants will be treated equally before the law, and we'll have our rights protected and vindicated in the meaning of citizens. The corporate body doesn't have constitutional rights, but us as individual citizens, we are all afforded constitutional rights. And it's only when we're treated equally before the law and our rights are protected and vindicated that the state can ensure that no citizen is deprived of their personal liberty. So it's very important to remember that we have the power to do this. We don't have to engage with An Garda Síochána or the DPP or the Attorney General. When we walk into the High Court and we're able to give evidence to a jury, we don't need to engage Article 30 of the Constitution of Ireland. Article 30 of the Constitution of Ireland is only engaged if you're not able to prosecute your own complaint and give your evidence to the judge and the jury themselves. And unfortunately in Ireland, that system has been abused for the last 90 years, where the DPP sometimes do not bring matters before the courts when they concern public servants, civil servants and corporate bodies. But the Constitution allows us to do it ourselves. And like I always keep saying, it's up to us to get our bodies into the court to protect our fundamental rights in the pursuit of justice.